We wanted to perhaps explore a few questions, and in part to bridge the difficulty with presenting to both an audience who are not so experienced in this area and those who are very experienced. We thought we would have a bit of a question and answer session and ask you to join us in that. Sadly, technology is not entirely on our side and we have one microphone. So I'm going to ask you either shout, and if that doesn't work terribly, I'm going to have to run into the audience and give you the microphone. But can I start by asking perhaps the first question to Tiphanie, which is that you've explained that part of the process is at some point a claimant often has to decide to refer either to VCAT or the Supreme Court. There's a monetary limit in the Act, but I think it's now so old that it's probably not of any great relevance to anything. What factors do you think are appropriate to consider in making that election?
Sarah, yeah, there's a monetary limit in section 81.
Break her off here.
Sorry?
Not working?
It's gone again.
Oh. Was it working for me, or?
Partly.
I think
It's 50.
it's
Yeah,
got to
it's
be
50.
very close.
It's $50,000, which means it's not really much of a consideration. So anything under $50,000 goes to VCAT, and anything over goes to VCAT or the Supreme Court.
Well, it doesn't have to. Obviously, a claimant gets to make an election. So
Yeah.
on what basis do you think you'd make that call?
Part of the consideration would certainly be the complexity of the claim. If it's a very complex claim, you probably want to go to the Supreme Court. The costs are going to be higher in the Supreme Court, so that would be a consideration. If the claim involves, it's stopped again, hasn't it?
Stop again.
Just shout.
If the claim involves an underlying planning issue, it might be that you want to take the claim to VCAT because it goes into the planning and environment list. There used to be a land valuation compensation list, but it's been subsumed into the planning and environment list. So if the claim involves underlying planning matters, it may be that you want to take advantage of VCAT's expertise in that area, because obviously the members at VCAT have underlying expertise.
Would cost sometimes be a factor as well?
Yeah, cost of the claim, and also strength of the claim in terms of the costs that might be awarded. Obviously, to get someone to appear for you in the Supreme Court is going to be a bit more than appearing in VCAT. The processes are fairly similar though, so but VCAT obviously is a little less formal, so the culture of VCAT, if you're used to the courts, is a little bit Wild West, and similarly if you're used to VCAT, then the culture of the court, you can find it quite formal. It's very different. It's a very formal process in the Supreme Court, and it's a very managed process in the Supreme Court. So those would be the considerations.
And for Andrew, there were some recent amendments to Section 26 of the Supreme Court rules. Do they have an effect on this area and the way perhaps the court's doing business in this area?
Yeah. Well, yeah, so to Order 26, that's right, that was amended earlier in the year. Now, of course, the decision of Gobbo and Coastal Estates means that you can't rely upon an offer of compromise under the rules in a Supreme Court case. But it is perhaps relevant because what the amendments did was also allow, well, firstly, remove the definition of claim from what could be the subject of an offer of compromise. And I think that's probably significant because it illustrates the policy, the emerging policy of the courts to encourage settlement of cases. And so that seems, although it's not been tested as far as I'm aware in the courts, I think that the removal of the definition, to my mind, invites offers for particular aspects of claims. It's no longer tied to the claimant's entirety. And the second relevant one, I think, was that it allows offers to be expressed inclusive of costs. But again, that's further to my comment at the end of the presentation. It's another avenue that's now been recognised by the courts of settling cases and further being relied upon in the court's consideration of the cost consequences of failing to accept offers. So I think it's just part of the emerging process. While it doesn't have direct effect, I think it just reflects what's happening.
Before I open it up, one of the things that certainly in my experience happens when claimants first approach solicitors and by extension the bar, one of the first things they're most worried about is whether or not the acquisition is proper, whether or not the authority can actually take the land, which frequently by then is taken. I'm interested in, and it's really a question for Tiffany and Andrew, and I have some observations arising from law, as to whether the time spent on checking whether the acquisition is proper, interrogating all aspects of the way in which the claim was gone about is, in your experience, time that is well spent or money well expended in terms of costs, or whether that's an area that's perhaps been less fruitful, particularly in Victoria, bearing in mind there have been some successful litigation in New South Wales and certainly Western Australia arising from the way in which the acquisition's been gone about.
It's interesting because claimants or clients in this area can be very passionate. They can't steal my land. They can't take it away from me. And sometimes you'll get clients that just will not accept that it is possible for a public authority to acquire their land against their will. And they will be looking, understandably, they'll be looking for everything, every avenue to find out, to find a way to make it not happen. Unfortunately, in my experience, although I understand the New South Wales cases that you've referred to, in my experience it's not a fruitful line of investigation. It may serve simply to allay the client's fears that what was being done was illegal, but it doesn't always. It can be throwing a lot of money down an unfruitful path of inquiry. You might have some comments in relation to love about that.
Oh, look, I'd agree.
Or you might not.
I mean, an acquisition for a public purpose is a very, very broad power. I mean, one of the difficulties, for example, because Mr. Love challenged, Mr. Love owned a property in Cooper Street, Epping, and was in the process of securing permits to operate an extractive industry on his land. And the incoming Labor government, and Mr. Love happened to have some ties with the Liberal government, the incoming Labor government in 1999. It was one of the first executive decisions they had made was to refuse Mr. Love's permit and then say that, well, that clears the way then for us to relocate a freeway, which happened to be across the next adjoining property, onto Mr. Love's land, right through his proposed quarry. Now, Mr. Love took that all the way to the Supreme Court. And look, I mean, one of the, without going through the niceties of it, he ran it basically on Wednesbury. It was unreasonable that they did case. But one of the hurdles that he ran into was that by the time the case was being heard, there were 100,000 vehicle movements of the freeway running up and down his proposed quarry. So there's no way that the court was ever going to relocate that. He was able to, the freeway, I mean, it just was never going to happen. He was able to initially secure an injunction protecting an old homestead on the property, but ultimately that even he wasn't able to maintain that. So there are enormous difficulties, expense, and practical problems in challenging acquisitions. There's limited value, I would have thought.
Yeah. Sorry, can I just say also that for some people, it's not about the money because it's they're very emotionally attached to this. But whether it's going to be possible to find something wrong when it's a process that is in place, it's for a public purpose, and it's done so often, it's very unlikely that even if you find fault in it, that it won't be able to be fixed in some way by the minister or by the process anyway. So.
I say that in part in the directions hearing some time ago when on a $325,000 claim before the Supreme Court, there were all sorts of foreshadowings of effectively unpicking a 2.5-year-old acquisition. And interestingly, even the court in that instance was prepared to go as far as to say, if you're going to embark on that process, you want to take some very serious legal advice and you want to be very careful of the size of the claim. And I think that was good advice, and ultimately the matter, as so many of them do, settled for a pretty reasonable sum on the valuation matters alone. Probably time for some questions from the audience. Are there some questions for Tiphanie and Andrew? Thanks.
What were some of the underlying planning considerations you were referring to there, Tiphanie?
If you've got a planning permit issued on the land, that perhaps you're in the process of actioning, so you're doing the development at the time, or it's simply approved but hasn't been actioned, so there's the potential for development there that's already been approved, then that would be that would affect the amount of compensation that you can claim, and so you may want to have town planning evidence. In terms of VCAT, there is the tribunal members have inherent expertise in planning, valuation in different areas. So although it will depend on which member you get, the tribunal has expertise, whereas judges of the court obviously know everything, but they didn't necessarily work as planners because they were often barristers or solicitors.
On a reasonably frequent basis, the planning situation of the property is something that the valuers will take into account. So particularly for some of the outer-lying properties within the urban growth boundary, you often get quite big disputes about what exactly the development potential of the land is, when is this residential subdivision that's foreshadowed going to happen in 10 years or 2 years, and how does that affect the value of the land. And they're the sort of planning considerations that it's arguable sometimes that VCAT can get their heads around more quickly sometimes than a Supreme Court case, I think.
So it goes to valuation questions, not to any question that might be raised about the appropriateness or admissibility of the use of that land for the project purpose.
I think that's generally the case, yeah. And I think if it was a challenge to the acquisition itself, that would more properly be a question for the Supreme Court rather than one that VCAT would necessarily handle. Indeed, it probably wouldn't even come directly under this process, but by sort of collateral means in general. I have a question for the audience, which you may or may not like to assist me with. I've had a very, very strong view until recently that where compulsory acquisitions go to mediation or compulsory conference, that should be conducted by someone who actually knows, ideally, an awful lot about land acquisition, and that you shouldn't be engaging generalised mediators to do mediations or compulsory conferences in valuation matters. I have reasonably recently had something that I think the last gasp was referred to a generalised mediator, one of the Associate Justices at the Supreme Court. And I've had a rethink of my views because it wasn't someone who I think of as a land acquisition person, but the skills of a good mediator, arguably, I was starting to think were more important than someone who actually knows the area. So I would be fascinated to hear whether others have a strong view on that and which side of my newfound evangelical views you might sit.
I agree with you.
Which one? My old view or my new view?
New view.
Yeah.
Because the long and short is everybody understands the process but the claimant. Full stop. If the mediator can't reach the claimant, we don't have problems.
So if you've got a good mediator who can reach the claimant, it doesn't matter.
It's not to say the claimant's the one that has to move. It's to say that the claimant's the one that needs to understand things from a lay perspective. And when it comes to everyone else, well, they pretty much know how things are. They understand court processes, and like pretty much any mediator will know about court processes. But it's not to say that there isn't value in understanding the acquisition process, particularly if you might have a solicitor on one side who's not that familiar with it. But I think the claimant's really the wild card on the mediation.
I'd agree with that, for a slightly different reason. Often the risk you have when you have an expert mediator in the area is that they sometimes move from the role of mediator to being an adjudicator. They slip into that role too much, and I think what you really want is a very good mediator. And if they have other skills, well and good, but I think that's their primary role.
No one's agreeing with my strident view about 6 months ago. That's all right. We all learn.
Can I ask this question in terms of the caveats on the transparency of instructing valuers? How does that translate to the conversations that take place at and after a valuer's conference between the valuer and the instructing system?
So as opposed to the conversations which necessarily retain a level of privilege within the conference itself.
Well, I mean, there obviously has to be a conversation after the valuer's conference in terms of reporting back and assessing the position. I think it very much, contact with experts, necessarily there's going to be a level of informality. I mean, everyone will pick up the phone and say, look, I've got a case, I need a valuer, these are the issues, is it something you're experienced in, or are you available, what sort of time frame? There's going to be that sort of incidental contact. That particular example, so evaluation conference, the opinion's in by that stage in general. So the view's been given, the evidence has been expressed in a formal report. So there's no problem with in my view, talking with valuers post-evaluation conference in terms of assessing, strengths, weaknesses, and then falling out of that any other settlement negotiations or offers and so on. I think the critical thing is that at that point the experts express their views, and it's not the case. On the record.
It's on record, and you're not looking at that stage, or you won't be perceived to be trying to influence the valuer in terms of the substance of their opinion.
Some more questions? Good. Otherwise we're going to have to have more of mine.
Is there any potential for research for restrictive covenants in where claimant is wanting to actually oppose the use of his or her land for the project?
Sorry?
You mentioned the effectiveness of the discovery of restrictive covenant in the case of Portland Hospital. Has this got any other application where people's domestic property is concerned?
Okay, not in quite the same way as the hospital case. That was specifically in relation to issuing a town planning permit. So the Planning and Environment Act has a provision that says that if the development is going to if it's not going to comply with an existing restricted covenant, then even if VCAT wants to approve the development on the merits, they can't. If it will be out of kilter with the restricted covenant. Now that doesn't apply in terms of valuation, but it will affect the amount of compensation that can be paid. So a restricted covenant will feed into that compensation claim consideration, and you'll discover that there is one on the land by looking at the title, because it's on the title. So not in the same way. It's not a way to stop compulsory acquisition, putting restrictive covenant. These are very broad powers, and they came about because when you start having cities, you start needing to plan them and plan them for the public. So there's a public purpose in being able to build roads and infrastructure, and that's why the powers are so broad. that they trump that concept of private ownership, because you need to be able to plan these things in order for cities to work.
The real relevance of a restricted covenant frequently in a valuation case is the effect it has on the value of the land. So if you've got a restricted covenant that says you can only build one house here, that you might otherwise have an expectation of a block of apartments, then that's going to act as a restriction on the value, and could probably have more to do in that sense and less to do in a sort of blocking sense as it might do in a planning application phase.
And I've got a question I can ask the people in the room too, if I may. The Supreme Court rules, Order 44 have recently been amended as well, and it now provides that, I mean, in this jurisdiction it's probably leading the way in terms of concurrent evidence, hot tubbing and so on, and putting the experts together to produce a joint report on issues that are mandated or agreed between the parties. But the new amendments to Order 44 now empower a court to order that one single expert be jointly appointed by the parties, and that the parties go away and agree on a series of facts and assumptions and instructions. And although the court is not necessarily bound by what's in the report, it's a significant change, I think, in the way cases are presently run. And you know, my initial reaction is, well, that offends a party's ability to run a case and prove a case the way they want to. And in my experience, that is likely to be quite an expensive exercise as well, to result in several directions hearings and perhaps contested situations where one party can't agree with the other as to the appropriate instructions and so on. I mean, I haven't sort of been the subject of such an order. Has anybody experienced that or got a view about the merits of the court appointing one expert in an appropriate case because it's a significant change.
I'd be astonished to see it used in this area.
Yes.
It's probably in the retail leases that when you've got this leasing disputes, and we get a valuation from our valuer and the landlord or the tenant gets theirs, and you have the great fight, and then it goes off to the umpire, another valuer, and you're bound. Unless you can error of law, you're going to be bound by it. So that sounds a little bit like they're heading down that way, where you get your two valuers that I've paid for, you've paid for, and going up with this one.
Well, no, in fact, it cuts it off at the knees there. It's at the initial stage. There's the parties that don't retain individual experts.
But how do you put a solution to this valuer?
Yeah.
No, that's
that's the fertile area of debate. I was wondering how it's going to play out.
By the time it's referred, both parties will usually have a valuer. They'll usually have a valuer's report, whether it's on the record or not. So the idea that you then ditch your experts for
that I think is the way it's intended to work in an appropriate situation. So I wonder whether it'll ever be exercised.
I'd be surprised to see it in this area, but
it's a bit more analogous in a building dispute where you'll have an expert determination. So is the brick wall straight or is it not straight? Rather than have 10 opinions about it, you get one person say yes, it is straight, or no, it's not, or whether the painting is done correctly, and that's sometimes used in
I'm sure it will have application, but I'm doubtful whether it's going to arise in this jurisdiction.
What are the other?
I was thinking in terms of construction, the Security of Payments Act and that adjudication process where you put your submissions in and then the adjudicator makes a determination. It's a little bit more like that, where you just have one person as the umpire. But then with the adjudication process, what happens is you make submissions back and forth constantly. So how are they going to manage that?
Well, this is I think it's going to be difficult to manage, but anyway, it'll no doubt emerge. It's only a recent amendment. So.
One of the other amendments that came in with that set was this idea that you now have to get, in effect, consent from the court to call expert evidence at all. And I know from the court has a sort of users of the list meeting from time to time. I suspect that some of the people in the room were at it, that the indication seemed to be that probably wouldn't have a huge impact in this particular area of law, because experts were so central to it that the idea that the court was going to say, no, look, you can't bring an expert was sort of foreign, and the indication seemed to be a sort of business as usual approach. But there seemed to be a sense that the court was going to be taking a fairly directive approach in relation to how matters would run, but that's probably not that different to the way a fairly managed list runs.
That's interesting because
In any
I think that's probably the difference. It's a managed list. So for example, obviously personal injuries, and that doesn't apply to the damages compensation list in the county court specifically. So,
more questions? It being 8:56 might be an appropriate time to wrap it up. Can I thank and ask you to thank our speakers very much for their time and